Hi, I'm Mike Vanderpool with the law firm of Vanderpool, Frostick Nishanian. You know, in today's economy, small businesses and medium-sized businesses can't afford to have a lot of problems. But one problem that I see that many of them have is the lack of a buy-sell agreement. And this can create very serious problems. Let me give you 3 examples. A business owner may wake up one day and find out he has a partner or shareholder that's a complete stranger to him or to her. A second problem may be when that business owner wants to retire and have the company buy his or her stock and finds out that the minority shareholders can block the purchase of that stock. And perhaps most difficult is when an owner who has spent his or her entire life building this company, creating value for his or her family, gets an offer to buy the company, and all of a sudden finds out he or she can't sell the company without the consent of the minority shareholders, who may either say no or may say, I'll only agree if you give me a bigger piece of the pie. All serious problems. And all of those can be addressed by a buy-sell agreement. So who needs a buy-sell agreement? Well, the general rule is if you have more than one owner of a company, you need a buy-sell agreement. Doesn't matter whether you're practicing in the corporate form, if your business is a limited liability company, or it's a partnership. If there's more than one person that has any ownership interest, you absolutely need to have a good, solid buy-sell agreement. Now, what kind of things will a buy-sell agreement cover? First of all, it will cover what happens when an employee wants to leave that you've given stock to. It's very common, for example, to have stock given to an employee. When that person leaves, they're free to sell it to whomever they want. Hence, you may wind up with a stranger in your business. Or they may decide to keep it, and they may be disgruntled and can be a big thorn in the side of a CEO because they're a minority shareholder and they have certain rights that they will exercise. Another area is what happens when the owner wants to retire, dies, or becomes disabled. There needs to be an agreement in place that will require the corporation to buy that individual's stock to protect both the corporation or the other business entity and to protect the person that wants to sell. With regard to the sale of the company, there also needs to be an agreement in place to make sure that the minority shareholders cannot interfere with the rights of the majority in selling that business. What issues need to be addressed? There are several. Probably the most important is how are we going to value this? How are we going to decide what is going to be paid for that stock? And there are different techniques that can be used here. One is an agreement of the parties. That has some problems with it. You can also use a formula. That can have some problems with it. Or you can use an appraisal, and that can have some problems. The key here is to decide which of these work and then have an agreement that addresses the problems that are unique to your particular business. One size simply does not fit all. There are a number of other things that you need to consider with regard to a buy-sell agreement. For example, how will you fund the purchase? You may need to have the company buy life insurance or to create a sinking fund, and those provisions need to be in the buy-sell agreement as well. When it comes to the sale of the business, you need to make sure that your buy-sell agreement includes what are called drag-along rights and tag-along rights. Stated simply, these are agreements that provide that if the majority owner wants to sell, that he has the ability to force the minority shareholders to sell as well. And in contrast, if you are a minority owner of the business and the business is sold, to make sure that you get paid for your stock as well as the majority shareholder. In closing, let me emphasize, this is not an area where you want to download a form from the internet. It's a complicated area, requires a lot of thought, a lot of planning, integration with your estate plan, and very careful drafting. So if you don't have a buy-sell agreement, or if you have a buy-sell agreement that was done several years ago, my advice to you is go see a good business attorney and get a good updated buy-sell agreement.